Okay, the 37th Circuit Court is now in session with the Honorable Brian Kirkham presiding. Today is Wednesday, March 15th, 2023 at 10:03 a.m.
Good morning, Ms. Brown.
Good morning, Your Honor. How are you?
Good, good. And you can proceed whenever you're ready.
Okay, thank you. Docket 2017-3074 DS. The respondent is Stephen Caceres. I did speak to Mr. Caceres this morning. He resolved his warrant through front of the court, so there's no bond to address. He's currently unemployed and looking for work, but also facing an unrelated criminal matter. So front of the court is asking that we adjourn this matter till June 21st at 8:45 a.m. to monitor the ongoing criminal matter.
Okay. Court would adjourn the matter to June 21st, 2023 at 8:45 a.m. to monitor Mr. Caceres's criminal case.
Thank you. 2018 and 2849 DS. The respondent is Ashley Crandall. I spoke to Ms. Crandall this morning. She did post a $200 bond and she has agreed to forfeit that bond. She waived her right to a hearing today. In front of the court is asking that we adjourn this matter till June 21st at 8:45 a.m. to monitor Ms. Crandall's employment status.
Okay. Court would forfeit the bond previously posted by Ms. Crandall and will adjourn the matter to June 21st, 2023 at 8:45 a.m.
Thank you. 2018, excuse me, 3223 DS and docket 2020-2533 UN. And the respondent in both cases is Robbie Curtis. I spoke to Mr. Curtis this morning. He did provide his employer. So front of the court is asking that we adjourn this matter till April 19th at 8:45 a.m. to allow front of the court the opportunity to establish an income withholding order.
Court would adjourn both matters to April 19, 2023 at 8:45 a.m. to implement income withholding.
Docket 2019-747 DS. The respondent is Stephen Caldwell. I did speak to Mr. Caldwell this morning. He reported that he has 2 interviews today. So front of the court is asking that we adjourn these matters until April 19th at 8:45 a.m. to monitor Mr. Caldwell's employment status.
Court would adjourn the matters to August 19, 2023 at 8:45 a.m. to monitor Mr. Caldwell's employment status.
April, Your Honor, you said August.
That's it?
April 19th, you said August.
I said August. April. I meant April. I'm sorry.
Thank you. Docket 2020-1470 UM. The respondent is Timothy Collins. I spoke to Mr. Collins this morning. He waived his right to a hearing. We agreed that Mr. Collins would pay $1,000 by the end of the month. So front of the court is asking that he be ordered to make a $1,000 lump sum payment by March 31st. And we adjourn the matter till April 19th at 8:45 a.m. to monitor compliance.
Court would order Mr. Collins make a lump sum payment of $1,000 no later than March 31st, 2023, and will adjourn the matter to April 19, 2023 at 8:45 a.m. to monitor his compliance.
Thank you. Docket 2010-438 DP. The respondent is Michael Cole. I spoke to Mr. Cole this morning. He has made substantial efforts to be compliant with the front of the court order for child support. Front of the court is asking for one final adjournment till May 31st at 8:45 a.m. just to monitor his compliance.
Court would adjourn the matter to May 31st, 2023 at 8:45 a.m.
Docket 2012-2635 DS and docket 2019-2015 DP. The respondent is David Karras. I did speak to Mr. Karras this morning. He reports currently being unemployed, but having medical issues that prevent him from maintaining employment. He posted a $300 bond on a 2012 case and a $200 bond on the 2019 case that he has agreed to forfeit and apply to the arrears. So friend of the court's asking that those bonds be forfeited and applied to the friend of the court arrears, that Mr. Karras be ordered to submit medical documentation speaking to his ability to gain and maintain employment, and that we adjourn these matters till April 26th at 8:45 a.m. to monitor.
Court would forfeit the bonds previously posted by Mr. Karras. Would order that he would provide the friend of the court with medical documentation as to his ability and restrictions to work. And will adjourn the matter to April 26, 2023 at 8:45 a.m. to continue to monitor this.
Thank you. Docket 2009-3541 DP. Docket 2013-2437 DP. Docket 2016-2483 DP. And docket 2021-1969 DS. The respondent in those four matters is Corbin Colon. Mr. Colon did bond out of the Calhoun County Jail. He posted a $200 bond on the 2009 case and a $100 bond on each of the other three. He has agreed to forfeit those bonds to friend of the court. Additionally, there is a $119.36 transportation cost that was not addressed at the bond review hearing that the sheriff is seeking reimbursement for. Mr. Colon waived his right to a hearing today. He's agreed to go into the LEAP program. So friend of the court's asking that we forfeit the bonds to friend of the court, that we address the $119.36 transportation costs to the sheriff, that we order Mr. Colon into the LEAP program and adjourn these matters until April 19th at 8:45 a.m.
Okay. Court would forfeit the bonds previously posted by Mr. Colvin. The court would order that he participate in the LEAP program and that he would reimburse the sheriff $119.36 for transportation in this case, and will adjourn the matter to April 19, 2023 at 8:45 a.m.
Thank you. Docket 2008-1071 DP. The respondent is Antonio Cisneros. And docket 2014-416 DC. The respondent is Natasha Coy. Both respondents failed to appear today before your honor. Friend of the court's asking that bench warrants issue for their arrest.
Okay, court would enter a bench warrant for Mr. Cisneros and Ms. Coy as a result of their failure to appear on today's hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater in this case, each of the cases.
Thank you. And then the following are requests for bench warrants for failing to appear before referees. Docket 2019-878 UN and docket 2021-2118 UN. The respondent is Bryant Carr. And docket 2006-3566 DS, docket 2014-2807 UE. The three respondents failed to appear for referee hearings. Friend of the court's asking for bench warrants and the bond set per statute.
Okay, I think you only gave me Mr. Carr's name. I don't know the names on the other.
Oh, I'm sorry. Docket 2006-3566 is Rena Coyle.
Coyle?
Yes. And
Okay.
then 2014-2807 is Robin Collins. My apologies.
Court would enter a bench warrant for Mr. Carr, Ms. Coyle, Mr. Thomas as a result of their failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor. That's all I have.
Okay, thank you. Well, we've got to get the jazz people up. That thing is still hard to hear. We got to get rid of the tinny, like echoey sound that's on that.
We'll get, talk to them later.
Yeah.
Give me just one moment, Judge. Is there one more person he's supposed to be meeting with and I'm not seeing?
Find out whose other courtrooms have been done. Go to, find out, whatever, go to those courtrooms and see if we need like to have Christie call in and see, do they have the same issues we're having? Or is it just our court?
Mr. Stackrider. I just sent a message about Mr. Wines. I don't see him here anywhere, but I'll put you back in the waiting and we'll continue with some other record matters we have, okay?
Okay.
All right. Okay, all right, so wait for my, okay, all right.
Good morning, Your Honor.
Good morning, how are you?
I'm well. How about yourself?
I'm doing well.
Good. The following matters were scheduled for a hearing before the assigned referee. The respondents have failed to appear and failed to comply. For another court request, bench warrants issued with bonds set at the statute amount and the mandatory $150 in local court costs. The bench warrants are for the following: 2012-19668DS and 2016-1800DS Ahmad Mood. 2007-4179 Andre Manuel.
Okay. Court would enter bench warrants for Mr. Moon and Mr. Manuel as a result of failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you. And the following matters was scheduled for a hearing before Your Honor today. The respondents have failed to appear and failed to comply. Front of the court requests bench warrants issued with bonds set at the statute amount. The bench warrants are for the following: 2005-0950 DP and 2005-2150 DS Antonio Player, and 2020-0898 DM Aaron Morse.
And what was the first name?
Antonio Player, Plair.
There, okay.
Mhm.
Court would enter bench warrants for Mr. Player and Mr. Morris as a result of failure to appear on today's date. The court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater.
All righty. And in the matter of 2014-1178 DP, Elizabeth Bennett versus Felix McShawn V, and 2019-3064 DS, Alicia McShawn versus Felix McShawn V. Friend of the court has met with Mr. Felix. He has waived his right to a hearing and an agreement was met for him. Friend of the court is requesting that this matter be dismissed to allow him to continue working with the LEAP program and that he continues to pay as ordered.
Dismissal is granted.
Thank you, Your Honor. That's all I have for today.
Okay, thank you. Have a good day.
You too.
All right.
Good morning, Ms. Flag.
Good morning, Judge. Are you able to hear me okay?
Yes,
All right, I just have matters for the record this morning.
okay.
All right, I will start with docket 2000-3680 DS. That is in the matter of Robinson versus Bottom. In this matter, Mr. Bottom is currently incarcerated in Calhoun County Jail on unrelated charges. And he's currently on no bond, so we're not sure exactly how long he's going to be incarcerated. Friend of the court is requesting that in this matter, we dismiss the adjourned show cause that was scheduled for today and order that Mr. Bottom contact friend of the court within 14 days of his release and that he also begin paying as ordered upon his release.
Court would cancel the bond previously ordered in this matter and order that Mr. Bottom would contact the front of the court within 14 days of his release from incarceration.
Thank you. Next is docket 2020-543-DS. This involves Caden Jones. In this matter, friend of the court's requesting that today's matter be adjourned to April 5th of 2023 to monitor his compliance. He begin paying as ordered and also make a $200 lump sum payment no later than March 17th, 2023.
Court would order that Mr. Jones would make a lump sum payment of $200 no later than March 17, 2023. And will adjourn the matter to April 5th, 2023 at 8:00 a.m. to monitor his compliance.
Thank you. Docket 2011-939-DS involving Heather Bell. In this matter, Ms. Bell was employed and compliant through the month of February, but she has lost that job. Friend of the court is requesting that the matter be adjourned approximately 90 days to allow her time to find new work and continue making her payments as ordered, and also that we forfeit the bond that she previously posted in the amount of $2,410.
Court would forfeit the bond previously posted by Ms. Bell, would adjourn the matter 90 days to monitor her compliance and her employment status.
Thank you. Docket 2012-3847-DM. This is involving Adam Fox. In this matter, Mr. Fox is currently still active in the KPEP program. He's scheduled to be released in a few days. And at that time, he'll be able to begin searching for work. Friend of the court's requesting that we adjourn the matter approximately 60 days to monitor that employment search as well as his compliance, and that he begin paying as ordered in the month of April.
And what was his name again?
Adam Fox.
Fox?
Fox with an F.
Okay. Reason we got this new system and it echoes and I can't hear the name very well, so. Court would order that this matter be adjourned approximately 60 days to allow and to monitor Mr. Fox's status and his compliance.
Thank you. And then we'll do docket 2013-1821-DP involving Randy Dunham. In this matter, friend of the court's requesting a 60-day adjournment to monitor Mr. Dunham's compliance. Beginning in April, he pay as ordered, and should he remain compliant, he would not need to appear at the next hearing.
Court would adjourn the matter 60 days to allow Mr. McDonough to come into compliance. If he is in compliance, then he need not appear at that hearing.
Thank you. Docket 2014-2272-DP involving Dusty Vasquez. In this matter, friend of the court's requesting a 90-day adjournment to monitor his compliance, a $400 lump sum payment no later than March 20th of 2023. He began paying as ordered April 1st of 2023. We establish his ordered on arrears amount at $72.50 each month. And should he be in compliance at the time of the next hearing, he would need not appear.
Okay, and unfortunately, I have to ask you his name again. I didn't catch it.
It's Dusty Vasquez.
Vasquez. Okay.
Yes.
Court would order that Mr. Vasquez would make a lump sum payment of $400 no later than March 20, 2023. That his arrearage would be repaid at a rate of $72.50 per month, and will adjourn the matter 90 days to monitor his compliance.
Thank you. And then I have docket 2021-2661-DM involving Charquan Barrett. This matter is on the docket list for today. However, it should not have been. I believe it was added to the docket in error. His hearing is actually scheduled for April 26th of 2023 before this court. So I don't think that matter needs to be heard today since it is scheduled for April, but it is on today's docket incorrectly.
Okay.
So I wanted to make sure you guys were aware of that.
We'll just remove the matter.
Thank you. And then I just have some bench warrants. Dockets 2010-2806-DS and also 2019-1703-DS. Both of these matters involving Renice Buchanan. Friend of the court is requesting that that a bench warrant issue for Ms. Buchanan due to her failure to appear for both of today's matters, and that bond be set pursuant to the statute.
Court would enter a bench warrant for Ms. Buchanan as a result of her failure to appear on today's date. Court would set her bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you. Oh, and I have one more here. Docket 1992-3019 DP involving Jerry Kinsley. In this matter, Mr. Kinsley is also currently incarcerated in Calhoun County Jail. Friend of the court is requesting that his bond be canceled and he be released forthwith on the friend of the court matter. He is ordered to pay the transportation cost in the amount of $333.50. And friend of the court requests that this hearing be dismissed.
Court would dismiss cancel the bond previously ordered for Mr. Kinsley. Order that he pay the transportation costs to the sheriff in the amount of $332.50. And we will dismiss the matter.
Thank you. And lastly, matters from referees. Dockets 2022-513 DS involving Mr. Bozell. Docket 1998-2270 DC involving Mr. Blowers. And docket 2017-3432 DC involving Mr. Lons. In all three of these matters, the respondents failed to appear for show cause hearings before the referee. Front of the court's requesting that bench warrants issue with bond set pursuant to statute and the $150 local court costs.
Court would enter a bench warrant for Mr. Moselle, Mr. Weller, and Mr. Lon as a result of their failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Judge. That is all I had for today.
Okay, thank you. You have a good day.
You too.
Good morning, Ms. Bhutan.
Good morning, Your Honor. How are you today?
Doing well. You?
I'm well, thank you.
Good. Go ahead whenever you're ready.
Okay, I have docket 2016-1170 DS, Kyles versus Sterling. The respondent, Jeffrey Sterling, was ordered to appear this morning for an adjourned compliance hearing. Mr. Sterling did phone in but failed to respond when friend of the court called him back. However, income withholding has been established. We've received one payment. So friend of the court is requesting to adjourn this matter until April 26, 2023 at 8:00 a.m. to monitor his compliance.
Court would adjourn the matter to April 26, 2023 at 8:00 a.m. to monitor Mr. Sterling's compliance.
I have docket 2017-0381 DS, Telementes versus Young, and 2019-0643 DS, Flemister versus Young. In both of these dockets, the respondent Philip Young was ordered to appear this morning for an adjourned show cause hearing. Mr. Young did appear. Friend of the court did speak with him, and he stated that he is currently looking for employment. He did waive his right to appear before Your Honor. Friend of the court is requesting that he be ordered to make a $30 lump sum payment on each docket by March 30th, 2023, and the matters be adjourned until April 12th, 2023 at 8:00 a.m. to allow him to gain employment and monitor his compliance.
Okay, and what's the individual's name?
Philip Young,
Jones?
Young, Y-O-U-N-G.
Yorn, okay. Court would order that Mr. Yorn would make a lump sum payment in the amount of $30 in each case, no later than March 30, 2023, and will adjourn the matter to April 12, 2023 at 8:00 a.m.
Thank you. And then I just have two matters for referee bench warrant hearings.
Okay,
The respondents Capri Smith, docket 2009-3540 DP, and George Abbott, docket 2017-0905 DS. Both failed to appear before referee Bradfield and referee Delmont on March 10th, 2023 and March 13th, 2023. Friend of the court would request that bench warrants be issued for their failure to appear and that bonds be set pursuant to statute.
court would enter a bench warrant for Ms. Smith and Mr. Abbott in this matter as a result of failure to appear at their respective referee hearings. Court would set their bonds in the amount of 25% of the outstanding arrears for $500, whichever is greater, and further would assess court costs of $150 in each case.
Thank you, Your Honor. Then I just have one hearing when we're ready.
Okay,
May as well, because everybody else that has met record also has hearings, so that's the Sanders case, right?
Yes, it is.
Okay, let me bring him in. Really makes sense. By the way, I also had a Terry Shaw. Was he on your list?
Who is that?
Terry Shaw
Mm,
from back in February 22nd.
No. What's the docket number?
2016-889 DS.
I'll check it.
Okay. Let's get here to this one.
this Mouton, who's the payer in this?
The payer is Melanie Sanders.
Okay. Ms. Sanders, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do.
And court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. My understanding, you wish to proceed without an attorney. Is that correct?
Yes, that's correct.
Are you doing so freely and voluntarily?
Yes, I am.
Has anybody threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No, they have not.
Okay, thank you. Court will find that Ms. Sanders does freely and voluntarily waive her right to an attorney. Before we commence, I'll have everyone, Ms. Sanders, Mr. Sanders, Ms. Mouton, raise your right hand. We'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
Yes.
Yes,
Ms. Mouton, you can proceed.
Your Honor, in the matter of Sanders versus Sanders, docket 2014-3256 DM, the respondent Melanie Sanders is before the court for an adjourned show cause hearing. Ms. Sanders is currently ordered to pay $548 per month for current support. Her arrears repayment are set at guideline and currently charging at $93 for a total monthly obligation of $644.50. Last payment received on this docket was on March 6, 2023 in the amount of $650, and that was paid by Ms. Sanders herself. This is her fourth show cause, second bench, or she's had 2 bench warrants and 1 previous finding of contempt. I measured compliance over the last 3 months. Ms. Sanders should have paid $1,933.50. She paid $1,351.50, leaving her a shortfall of $582. The shortfall at the time of her last hearing was $144.50 for a total shortfall of $726.50. Total arrears on this docket are $5,547.12 through March 15th, 2023. She's had no prior jail sentence. The contempt finding was on November 23rd by referee Bradfield. Friend of the court would also like to mention that her compliance was measured over the last 3 months. because she made her February and January payments on March 1st and March 6th. And the plaintiff, Devin Sanders, is the one that requested this hearing today, Your Honor.
Okay. Ms. Sanders, do you dispute or contest any of the statements made by Ms. Mouton?
No. I do not. I am $60 short of the 700 for March, and then I will be on track for April's payments.
Okay.
Yeah. I am working
you-
on it. I was told no excuses last time, and so I'm working on no excuses.
Okay. Do you have any questions for Ms. Mouton?
No, I do not.
Okay. What would you like to tell me, ma'am?
That I am working. I am about to put my change of address in on Friday, along with March's child support of the full payment of 700. So I will have a change of information for the second job that I picked up and all of March's. So I will be starting to get caught back up permanently.
Okay. So you're working 2 jobs at the current time?
Yes, I am. I'm working anywhere between 39 hours to 46 hours.
Okay. And who are you working for?
I work online through the streammates.com, and I also work at a strip club called Cracker Jacks in Jackson, Michigan.
Okay. Okay. Did you get both those places, Miss Mouton?
I did, Your Honor. Thank you.
Okay. Okay. Tell me, Miss Sanders, how did you get to be over $5,000 in arrears?
Due to my frustration, I decided to stop payments because I was no longer seeing my child, which I know is frowned upon. However, it was my way of coping. Sadly, not the best way of coping, but that is how I felt the easiest way to cope with not being allowed to see my son from September of 2000, I believe it was 20. So with that and just basically being in my own head, I got really depressed. I got really upset, and I let that pretty much get a hold of my work ethic.
Okay.
And
Yeah.
that would be why.
As you understand, and as you stated, it doesn't appear that that's a good response or way to handle it.
That is correct. Yes.
Okay. Anything else you'd like to tell me?
Not that I can think of. No, not off the top of my head.
Okay. Mr. Sanders, anything you would like to tell the court?
You know, it's been a consistent thing over the years, as the record was stated, and really, I was just blown away when she was found in contempt by her statement that was made to a friend of the court, and I feel that she's made her bed, and only you, Your Honor, can decide if she lays in it.
Okay.
I do have one question. It's more for Mr. Sanders himself, not really the court. Would it be all right if I ask?
Well, depends on what it is, because we're addressing the issue of support and your non-payment.
Right.
I'm not going to get into other issues with Mr. Sanders because they're not
Right.
used for this case today.
Well, my question had to do with why he chose to do today's court hearing instead of, again, waiting to see how well I follow through with the next court date in August.
Okay, well, he has a right. He has a right to pursue as long as there's an arrearage. So it doesn't matter what his motivation is. He has a right to do that. So. Do we have another hearing in August, Ms. Mouton?
No, Your Honor, not for this matter.
Oh, okay,
Not, okay. I didn't realize there were two separate matters. My apologies.
okay. Well, what I'm going to do is obviously you've been making payments, and again, there's some additional matters. You picked up another job, so what the court's gonna do is I'm gonna adjourn the matter 90 days, approximately 90 days to monitor your compliance. We'll be back in at that point and we'll see how you're doing. I would tell you it obviously would be beneficial to you to make sure you're making the current, which would include the payment on the arrearage as well. If the court comes back at that point, sees that there's no payments made, then you're gonna have to be prepared to go to jail. You understand that?
Yes, I do understand.
Okay. Okay, so we'll adjourn the matter and Ms. Mouton will send you out a renotice so that we can review it in about approximately 90 days.
Thank you.
Okay, thank you. You're excused and court will end this matter. Thank you.
All right. Very good.
Thank you, Your Honor.
I believe that's everything from you, right?
That is, and that docket that you asked me about, the Terry Shaw docket, that docket has been canceled.
Oh, okay. All right, very good then. So.
Yep, so I'm all set.
Thank you.
very
Thank
good.
you. Have a good day.
You
Yep.
too. Okay, we're gonna continue now. I'm gonna bring Liz, she has 2 hearings with Zach Ryder and
Good morning, Miss Wells.
Good morning, Your Honor.
How are you today?
It has been a busy morning.
Okay,
It has
well,
been a busy morning. How are you?
okay, so
Good.
whenever you're ready.
All right, would you like me to start with my record matters first?
Yeah.
yes.
Okay, awesome. So the following matters were scheduled for hearing before the assigned referee. The respondent has failed to appear and failed to comply. Friend of the court requests bench warrant be issued and the bond set at the statute amount with the mandatory $150 local court costs for the following individual. 2021 3292 DS Jason Wilson.
Okay. Court would order a bench warrant for Mr. Wilson as a result of his failure to appear at his referee hearing. The court would set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater. Will further assess court costs of $150 in this case.
Thank you, Your Honor. In the matter of docket number 2020-2409 DS Clayton Bowman. Last week, I requested a bench warrant be issued for a failure to appear before Your Honor. However, he did appear with another EO. Therefore, I'd like to cancel that request on record and rescind that request as it was made in error.
Court would vacate and cancel any bond previously or bench warrant previously entered in this matter as a result of Mr. Bowman's having actually appeared.
Thank you, Your Honor. And on today's record matters and the matter of docket number 2004-1867 DP Jason West. Mr. West has provided medical documentation as well as a medical affidavit from his doctor proving that he is doctor ordered not to work. Therefore, friend of the court requests the matter be set aside due to this medical condition at this time.
Court would set aside and vacate any order at this current time.
Thank you, Your Honor. And the matter of docket number 2018-1701 DS Tevin Wines. Mr. Wines is active in LEAP and is actively participating. Friend of the court requests the matter be adjourned 90 days to monitor that continued participation.
Court would adjourn the matter 90 days to monitor Mr. Wine's participation in the LEAP program.
Thank you, Your Honor. And the matter of docket number 2009-1099 DS Amy Wood. Ms. Wood has reported that she starts at a new employer next week. Friend of the court requests the matter be adjourned 60 days to allow an income withholding to go out and take place.
Court would adjourn the matter 60 days to allow income withholding to be implemented in this matter.
Thank you, Your Honor. In regards to docket number 2003-3652 DS Reginald White. Mr. White has agreed to a court-ordered lump sum payment in the amount of $100 by no later than March 31st of 2023. Friend of the court requests a 60-day adjournment to monitor that lump sum payment is made and that he pays as previously ordered.
Court would order Mr. White to make a lump sum payment of $100 no later than March 31, 2023, and will adjourn the matter 60 days to monitor his compliance.
Thank you, Your Honor. In regards to docket number 2007-4076 DP, Robert Easy. Mr. Easy failed to appear for his adjourned bench warrant hearing before your honor today. Friend of the court requests that the $1,256 bond posted on February 28th of 2023 be forfeited and a bench warrant issue for his failure to appear today.
Court would forfeit the bond previously posted by Mr. Easy. In this matter, would enter a new bench warrant as a result of his failure to appear on today's date. Set his bond in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor. And lastly, in regards to record matters, 2019-644 DS, Michael Neal. Mr. Neal called in for his hearing. However, I was unable to get in touch with him when I returned his call. Therefore, friend of the court requests the matter be adjourned to March 29th, 2023 at 8:45 a.m. to allow him the chance to appear.
The court would adjourn the matter to March 29, 2023 at 8:45 a.m. to allow Mr. Neal to appear.
All right, and that's all I have for record matters.
Okay.
So we'll get to your hearing. So I want to do the Wagner. So let me bring him in.
Okay.
It's been for an hour, I believe.
All right.
So this is with Attorney Sackrider and also, let me rename this person here. Kelly Bridges, just a moment. Can you hear us, ma'am? Unmute, please.
Can you hear me?
Yes, okay, let's go.
Okay.
Okay. Mr. Wagner, and this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges, sir?
Yes, I understand.
Okay, the court has appointed Mr. Sackrider to represent you in this matter. Have you had sufficient time to speak to Mr. Sackrider in preparation for this proceeding?
Yes.
And Mr. Sackrider, you ready to proceed?
Yes, Your Honor.
Thank you. We'll have Ms. Wills, Mr. Wagner, and is it, what's your, ma'am, what's your name?
Kelly Bridges.
Burgess? Ms. Burgess, we'll have you all raise your right hand. We'll have you sworn in, then we'll proceed.
Oh, for him to, Mr. Wagner, raise your right hand too, please. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes.
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 Okay. Ms. Wills, you can proceed.
All right. The docket before you, Your Honor, is 2019-846 DS in the matter of Ms. Kelly Bridges versus Mr. Derek Wagner, with Mr. Wagner being the payer. This is an adjourned enforcement hearing. I was adjourned to allow him to be represented by court-appointed attorney as requested. It was originally, prior to that adjournment, a bench warrant hearing for his failure to appear at a referee hearing on June 13th of 2022. The order being enforced today is the modified uniform child support order dated January 13th of 2020, which states that his current child support is $109. After servicing and processing fees, brings it to $112.50. His last payment was $148.28 on September 3rd of 2021 via unemployment. He has been show cause 3 times with 1 bench warrant and 1 finding of contempt. The previous 6 months at $112.50, he should have paid $675, and he has paid none.
Cause he's a bum.
As of February 28th of 2023, his total arrearages are $4,747.94. There have been no previous jail sentences with that previous contempt hearing. Mr. Wagner was booked in on March 3rd in the Calhoun County Jail on separate charges. When he was booked in on our warrant, he was in jail from February 16th to February 23rd.
Okay. Okay. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Wills?
No, Your Honor.
Okay, do you have any questions for Ms. Wills?
Yes. Miss Wills, has he been in jail since February 16th?
No, so he was in jail February 16th to February 23rd. He bonded out on the 23rd, and then he was booked back into jail on March 3rd. And he's been there since March 3rd on separate charges that are not FOC related.
Okay. And does he qualify for the LEAP program?
Nope.
No, so with Mr. Wagner, let me make sure that we have his correct address on file. The previous address, he does qualify for LEAP. However, due to, us not being able to get in contact with him and having the bench warrant for so long, he did not qualify. He does now, as long as he doesn't have any other warrants in the state of Michigan.
Okay, thank you. No further questions.
Okay. Any proofs, Mr. Sackrider?
Yes, I'd call Mr. Wagner.
Okay, go ahead.
All right, Mr. Wagner, can you hear me?
Yes.
You heard the testimony of Miss Wills, is that correct?
Yes.
Is there anything that you disagreed with?
No, sir.
Okay. So you were booked in, looks like February 16th, and then you bonded out on February 23rd by posting a $100 bond, is that correct?
Correct.
Are you willing to put that bond amount towards your child support arrearages?
Absolutely.
He needs to pay more than $100.
Okay, hold on a second. Ms. Bridges, we're taking testimony from Mr. Wagner, not from you at this time. You'll have an opportunity to speak after that, so please don't interrupt.
Okay. All right. Ms. Wills testified that you're being held on other criminal charges in the jail. Is that correct?
Yes, sir.
Do you have a hearing date or a release date for those other charges?
I have a release date on the 8th.
On April 8th?
Yes, sir.
You're expected to be released?
Yes.
Good. Prior to February 16th of 2023, were you employed?
No.
Lie.
Hold on a
Okay.
second. Just hold on. Ms. Bridges, was I unclear about not speaking or interrupting? Ma'am?
So what? Y'all can shake a piece of shit motherfucking hand and say
Hey,
congratulations.
ma'am, if you go off like that, you can be held in contempt of court and go to jail. Do you want to do that?
Just proceed to the fucking court hearing and shut up.
Ma'am? One more outburst or one more vulgarity and you will be going to jail. You understand?
Good luck.
What, ma'am?
I said good luck. Finish court.
Go ahead, Mr. Sackrider.
How are you supporting yourself prior to February 16th of 2023?
Odds and end jobs. Like I said, I've been unemployed. Just this and that, what I can get by.
All right. When was the last time you were employed?
Before fall.
Before fall of 2022?
Yes.
And what were you doing then?
I was working subcontracting to a construction company and I was terminated.
Okay.
I had not had time to be placed on payroll before I was terminated.
Okay. And so you've been homeless since that time?
On and off, yes.
Where do you stay mostly?
I was staying with my parents, but because of the ongoing charges, I have a no contact order with them.
Okay. Do you struggle with substance abuse?
No,
You
I have in the
struggle.
past, but not currently.
Okay. What is what's your highest level of education achieved?
10th,
Are you willing to pursue a GED?
eventually, once I get things in order.
Okay. And what can we tell this court that your plan is to meet these obligations if you were to be released from jail?
I have court on the 31st. I'm supposed to be placed on probation, which I will be required to gain employment, which upon gaining employment, I will be able to start making payments on my child support as required. I mean, besides that, there's really nothing else I could say.
All right. Would you be willing to participate with Miss Wills in the LEAP program?
Yes,
All right. So you would be willing to work with a temp agency and find employment and set up income withholding?
yes.
Okay. All right, so is there anything else that you would like to tell the court?
Nope, I think that's it, sir.
All right, I have no further questions, Your Honor.
Okay. Mr. Wagner, in the last year, how much have you worked?
Altogether, probably about 2.5 months.
And during that time, you obviously didn't pay any child support. Why was that?
I just failed to pay. I failed to pay. I mean, honestly, there's no excuse for it.
And during those 2.5 months, how much would you say you made on an average week?
About $200 a week.
Okay. When you weren't working, what were you doing to acquire employment?
Shovel snow, handyman work.
Okay. So just odd jobs during that time.
Yes, sir.
Did you apply for any employment during that time?
I have not had an ID, birth certificate, or social security card for quite some time. I had just acquired that previously before being incarcerated on the 3rd.
Okay. Let me ask you, you said that you will eventually seek your GED. Why have you not done it previously?
I haven't had the resources to, sir. Anything else that you'd like me to be aware of, sir? No, Your Honor.
Okay, thank you. Ms. Bridges, you can ask Mr. Wagner any questions pertaining to the issue before the court, which is his non-payment of child support. Do you have any questions?
I already know why his non-payment of child support is, why he's had a job the whole time working for Larson's Construction, making $26 an hour underneath the table for months now.
Okay, ma'am, this is your time to ask him. This is your time to ask him questions, not for you to give a statement at this point. So if you have any questions for him, ask those.
Okay, Derek, seeing you had money to buy alcohol, why were you not paying your child support?
I was terminated because you had contacted FOC before I had a chance to be placed on payroll, so I was terminated.
That's not my fault. You know you're supposed to pay child support. Pay your shit. Be a man. Instead of a bum drunk.
Thank you. Anything else, Mr. Sackrider? You're muted.
Nothing further, Your Honor.
Okay. Court will make the following finding in this matter. In this case, Mr. Wagner has a minimal support obligation of $148.50 per month, including his arrearage repayment in this matter that in fact, over the last year, he has, as he stated, he's worked approximately 2.5 months during that time, making $200 per week. On each of those weeks that he acknowledges that he simply failed to pay, and there's no excuse for not doing so. In addition to that, he did have odd jobs. He stated that he has been hindered somewhat because he has not had an ID or a birth certificate, etc., to acquire employment, but he has not stated any effort he's made to acquire that. Likewise with the GED, other than that he's had no money to do that. The court will find that he has had the present and the ability to pay, that he's failed or refused to pay, and therefore he is in contempt of court. Anything before sentencing, Mr. Sackrider?
Yes, thank you, Your Honor. My client testified that he will be on probation upon his release and his other criminal matters, and he will be looking for employment to satisfy this obligation. We would ask that any jail sentence be 31 days or less, with credit for 7 days already served in this matter. We would request a purge amount in the amount of $400. Thank you, Your Honor.
Thank you. Well, in this matter, Mr. Wagner, I could sentence you up to 45 days. I'm not going to do that only because it is your first time that you would have any jail time, even though you did have a prior contempt. There was no jail time at that point. What I'm going to do is I am going to sentence you to 21 days in jail with credit for 7 days served. And I'm going to put a purge amount in place of the amount of $500. If you're able to pay the purge amount, then you would not have to serve the balance of your jail sentence. Do you have any questions, sir?
No, Your Honor.
Okay. Court will end this matter at 11 a.m. You're free to go. Have a good day.
That's bullshit. You guys shake his hand and tell him congratulations.
Ma'am, the case is done. We don't need to hear anything else from you.
Fuck you. Bye.
Hold on, ma'am. The court is going to hold Ms. Bridges in contempt of court based upon the last outburst and the last vulgarity. Ms. Wills, do you have Ms. Bridges' phone number? Can you contact her and get her back?
Yes. Let me just go ahead. If you allow me, would you like me to go off record while I call her right now to get her back on the Zoom?
No, go ahead. We'll just hold on and put her on.
Okay. All right. Hi, Ms. Bridges. This is your enforcement officer. Judge Kirkham was wondering if you could please log back on to Zoom to speak with him. If you could please log back on, Judge was requesting that. Okay, just log right back onto the Zoom room and they'll let you in. She hung up on me. So I'm unsure if she will log back in or not.
Let me see. This may be her.
Okay. Yes, that's her.
Ms. Bridges, I had warned you multiple times about your outbursts and the vulgarity, and apparently that did not have any impact. What the court is going to do based upon the last outburst, ma'am, the court, is she muted? Are you muted, ma'am? You can unmute yourself. We can't hear you.
You don't want to listen to anything I say. You just want to shake this motherfucker's hand and tell him
Ma'am,
congratulations. Let's be a
ma'am,
piece
the
of
court
shit
is
father some more.
holding you in contempt of court. I'm sentencing
You
you
ain't
to
holding
3
me to
days.
shit, bitch. Fuck off.
3 days in jail, ma'am. You will be sentenced to 3 days in jail. You will have to appear on, we'll have her appear on March 17, 2023, no later than 4:00 p.m. to serve her 3 days in jail. If she fails to appear, the court will enter a bench warrant for her arrest at that point.
All right, let's move on to the Nelson. Case.
And is Mr. Belton the payer?
Mr. Christopher Nelson is the payer on both of these matters before you.
Nelson?
Nelson, yes, sir.
Okay. Mr. Nelson, in this matter, you're before the court charged with civil contempt of court due to your failure to appear, for your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand that, sir?
Yes, sir.
And in this matter, the court has appointed Mr. Sackrider to represent you. Have you had sufficient opportunity to speak to Mr. Sackrider in preparation for this proceeding?
Yes, sir.
And Mr. Sackrider, are you ready to proceed?
Yes, Your Honor.
Okay. Mr. Nelson, Ms. Nelson, we're going to have you, Mr. Wills has already been sworn in. We'll have you raise your right hand and be sworn in, and then we'll take some testimony from you in a moment.
Ms. Belton, also please raise your right hand.
Yep.
Okay. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Okay.
Yes.
Ms. Wills, you can proceed.
Okay. All right, Your Honor, there are two dockets with Mr. Nelson as the payer. The first docket is 2007-3497 DS. Brooke Ryan versus Christopher Nelson, with Mr. Nelson being the payer. This is an adjourned enforcement hearing that was adjourned from a referee hearing on March 15th of 2023. The referee did find an order of contempt of court when he adjourned this hearing before Your Honor. The order being enforced is the modified uniform child support order dated December 5th of 2018. His current monthly child support is $205 in combination with services and processing fees, brings it to $208.50. His last payment was $8.02 on March 10th. That was a personal payment that he made. He has had 4 show causes, 0 bench warrants, and 1 finding of contempt. That contempt finding was the adjourned referee hearing I spoke of. And the last 6 months, at a rate of $208.50 a month, Mr. Nelson should have paid $1,351. He has paid $24.06 on this docket. He did pay his ordered lump sum of $100 as well previously. The second docket is 2020-2117 DC, which is Ms. Kaylee Belton, who's present today before Your Honor, and versus Christopher Nelson, with Christopher Nelson being the payer. This is also an adjourned enforcement hearing from the referee to the judge, where he was found in contempt on this matter as well on March 15th. The uniform child support order dated April 19th of 2021 is the order being enforced on this docket. His monthly support is $1,000.73, with servicing and processing fees brings it to $1,076.50. His last payment was $41.98 on March 10th as a personal payment that he made it to friend of the court. He has been show caused on this matter 1 time with 0 bench warrants and the 1 finding of contempt from the referee hearing as stated previously. Over the last 6 months, at $1,076.50, he should have paid $6,559. He has paid $125.94. His total arrears on this docket are $24,869.34 as of February 28th of 2023. And I do apologize. I think I forgot to tell you his total arrearages on the 2007 docket, which are $3,000.84 and $3,084.61 as of February 28th of 2023. Friend of the court also just want to note that there was a 30-day jail sentence previously ordered in this case, dated October 7th of 2011 for the 2007 case. Mr. Nelson was in LEAP, but was termed due to applying for TruePath, which is a cash assistance. He can't be in both programs. So he's termed from LEAP, but also failed to participate in the TruePath orientation. And prior to that termination from LEAP, due to applying for TruePath, he was already going to be given a deadline due to not fully participating and submitting his list of jobs that he was searching for. And as stated previously, the referee did find him in contempt prior to adjourning this hearing before your honor.
Thank you. Mr. Sackrider, do you contest or dispute any of the statements made by Ms. Wills?
No, Your Honor.
Do you have any questions for Ms. Wills?
No, Your Honor.
Okay. Any proofs, Mr. Sackrider?
Yeah, I'd call Mr. Nelson.
Okay, go ahead.
All right, Mr. Nelson, can you hear me?
Yes, sir.
All right, you heard the testimony of Ms. Wills, is that correct?
Yes, sir.
Is there anything that you disagreed?
Speak up if you can, sir. It's a little hard to hear you.
No, I
Anything
don't.
that you
No.
disagreed with?
No.
Okay. It says here your last payment was $8 on March 3rd of 2023. Did you make a payment on these cases?
I just made a payment yesterday.
How much was that?
This morning I made a payment, $50.
All right, how much have you been paying?
$50 a week.
$50 a week?
Yep.
Okay. We have two separate cases here. Were you aware of those child support obligations?
Yes.
All right, the support amount in the 2020 case, the Miss Belton, is $1,776.50 per month. Were you aware of that?
Yes.
That seems quite high. Would you agree?
Yes.
Are you aware that you can file a motion to have that changed?
Yes, sir.
Are you willing to do that in the future?
Yes, I'm actually going to do that within the next couple of days.
Okay. How are you able to pay $50 per week?
I have been working a little bit. I haven't been steady. At this point, work's slow. I think I'm just going to get a different job and let them know that I need to pay my child support and have it taken directly from my check.
All right, where are you working currently?
Currently I work for myself. That's construction, remodeling.
Okay. And approximately how much do you make per week?
About $500 to $600 a week.
Okay. How long have you been doing that?
It's been on and off. I worked with a couple different people last year. I was off for a while. I just started back up at the beginning of this year after the holidays. And now it's been slow again. So it's been on and off for a little over a year, about a year.
Okay. Where are you currently living?
37 Pico Place.
All right. And who are you living with?
My fiance and my kids.
And how many children are currently in your care?
There's 4.
All right. So it's you, your fiance, and 4 children?
Yeah.
And how many of those children are yours?
2 of them are mine.
And those are with your fiance?
Yes.
And then she has 2 other children?
Yes.
Okay. Safe to say, do your expenses exceed your income right now?
Yes,
Okay. And is that why you're not able to pay your full child support obligation?
yes, sir.
All right, have you looked into obtaining a higher paying job?
I have, and that's what my plan is now currently. I'm just gonna look for something higher paying so I can get all this taken care of, get it out from underneath me.
All right, in the past, let's say, month, how many applications would you say you've submitted?
In the past month, none.
And why is that?
I've been working.
Okay. What's your highest level of education completed?
High school.
All right. Any issue with substance abuse or alcohol?
No,
All right. Are you currently attending any Summit Point?
yes.
Okay, and how often is that?
I meet with a therapist once a month, and I have group meetings every Thursday.
All right, and what is that for?
It's the programs they put you through. The one I'm in now is Living in Balance.
All right, has that been helping?
Yeah,
All right, you said you recently received a court filing from Miss Belton regarding a change of domicile, is that correct?
yes.
It's your understanding that she moved out of state?
I don't know for sure if she did, but I have a feeling that she has moved out of state and is not allowing me to see my son. I asked on Monday if I could pick him up for visitation, for my visitation, which was 6 to 8, and I was refused it.
All right, and how often do you have a custody order with Miss Belton?
Yes, sir.
How often do you have or how many children do you have with Miss Belton?
One.
And how often do you see that child?
I don't.
What is your court ordered parenting time?
I got Monday from 6 to 8 p.m. and then I got Tuesday 1 to got my papers here. Tuesday is from 1 to 8 p.m.
Okay. All right, anything else that you'd like to tell the court?
Nope.
All right, thank you. I have no further questions.
Ms. Belton, do you have any questions of Mr. Nelson?
I feel like I should have had my lawyer here, but I don't have any questions for him. No, I mean, I guess he has had over a year to have time with him. When he brought up his time that he got refused, he has not seen his son in over a year. And I was protecting my son. He doesn't know him. And I was not going to just have him be picked up by a stranger. I'm open to doing like supervised visits until my son gets to know him. But right now, I'm not comfortable handing him over because he has not been involved in his care.
Okay.
He has
Well,
not shown any
at least
attempt.
today, we're not dealing with parenting time today, ma'am, so.
Okay,
that's not
then I
an
have no
issue
questions.
That's not an issue before the court. Anything else, anything you'd like to say, obviously that pertains to the issue of support, ma'am?
Nope.
Okay. Thank you.
Yep.
Well, the court has heard the testimony in this matter of Mr. Nelson. He obviously has stated that he's well aware of his support obligation in these cases. He's well aware that he could seek modification of the support obligation, which he has not done in this particular matter. That he stated in the in the last year that he has worked off and on. And that during the beginning, since the beginning of this year, he'd been working, been making approximately $500 to $600 per week. Although that has just recently dropped off, as he stated, he said he's going to be looking for a higher paying job. Although in the last month, in reference asking, in response to his attorney's question, he said that he has not applied to any place in that particular time. That he does have a high school education and is capable of again acquiring employment and basically paying his support obligation. The court will find that he has had available resources in which to pay the support obligation, again making the $500 to $600 per week for a good period of the last year, and that he has failed to do so, notwithstanding the fact that he that he is, I guess you'd say that the market or his job has waned a little bit recently, that he's had income this year to pay, he has not done so, that he's failed or refused to pay, and that he has not, again, taken action to seek other employment. He's not been participating in the LEAP program, et cetera, that was available to him. As a result, the court will find that he is in contempt of court. Ms. Wills, if you could explain a little bit better, there was as you say, there was a 30-day jail sentence put in place in October 7th of 2022. What was that? Was that suspended?
It was October 7th of 2011 for the 2007 docket.
Oh, okay.
Yeah, I apologize if I jumbled the words up. I apologize, Your Honor.
Nope, I didn't get the year, so. Okay. Anything you'd like to say, Mr. Sackrider, before sentencing?
I would just say, Your Honor, that my client has been making an effort to pay. He's paying the $50 per week. We would ask that any sentence be suspended to allow him to continue to make payments and find employment that pays him more. If the court is inclined to enforce the jail sentence, we would ask that the purge amount be set at $400. Thank you, Your Honor.
Okay. Ms. Felton, is there anything you'd like to say before sentencing?
No.
Okay, thank you. Well, the court had previously entered a jail sentence in this matter, or in the other case, back in 2011, in the amount of 30 days. I could sentence you up to 90 days in jail. I'm not going to do that, Mr. Nelson. The court will, however, at this point, will sentence you to 45 days in jail with credit for no time served. The court would allow you to purge yourself in this matter by paying a purge amount of $1,000. And the court would order that you would, in fact, surrender yourself to jail on March 17, 2023, no later than 4:00 p.m. to serve your sentence unless you pay the purge amount prior to that time. That will be the order of the court. The court will end this matter at 11:21 a.m. You're free to go. Have a good day.
That's all of your matters, right, Liz?
I believe so, yes. Mr. Sackrider, Tevin Wines, we agreed on an adjournment, so I believe he did request the hearing with you, but he waived his right to appear and agreed to adjournment, so I don't need you for that one.
All right, thank you.
Yeah, of course.
Okay, very good. So we'll move on now.
Okay, Ms. Wills, if you would, make sure you follow up on that one with Ms. Bridges so that we have an order coming in on that. I mean, only because it's an unusual matter.
Yes, I already have a note to email my supervisor and see how to proceed with that.
Okay, thank you.
All right, have a great day, Your Honor.
All right, we will see you later.
Bye.
All right, we will see you later also, Kevin. And that's all for today.
Okay, we don't have any more hearings?
Not for him, but we do have one more.
Okay.
That is gonna be with somebody, with another attorney.
Okay, thank you, Mr. Sackrider. You have a good day.
Thank you.
All right, we'll see you later. Okay. Heather has a few matters for the record and then one hearing, the person is bringing his own attorney.
Okay. Good morning, Ms. Petrulio.
Good morning, Your Honor. I have one hearing and then I have record stuff. Which do you prefer I start with?
Why don't we do the hearing and then we can go to the record stuff and get the hearing out of the way.
Okay, and actually, I'm gonna read the prep sheet and then I have some stuff to add after that, just so you know.
Okay.
All right, let me bring them in here. And also, let me just make a quick modification here.
Rogers, the attorney.
He's using his, no,
Mr.
it's,
Mr. Robinson.
yes.
Okay.
And it's formerly known as. And.
Ms. Petrulio, Mr. Huffman, the payer.
Yes, he is.
Okay, thank you. Okay. Mr. Huffman, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes.
Court notes that you have Mr. Robinson representing you in this matter. Have you had sufficient opportunity to speak to Mr. Robinson in preparation for these proceedings?
Yes.
Mr. Robinson, are you ready to proceed?
I am, Your Honor.
Okay, what we'll do is we're gonna have, we'll have Ms. Petrulio, Mr. Huffman, and the respondent as well. We'll have you all raise your right hand and be sworn in, and we'll take testimony after that. Ma'am, that would include you as well.
Ms. Rogers, can you hear us?
She can't. She sent a message that says she's having troubles hearing.
That's,
Okay,
I don't know what to do about that one. It shows that she's muted. Maybe that is doing something.
yeah, she is muted. Okay, well, we'll swear in Ms. Petrulio, Mr. Huffman, and then we'll deal with the issue with Ms. Rogers.
Okay, very good. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
I do.
Can you send Ms.
Yeah,
Rogers,
send her.
we're gonna send Ms. Rogers an email and see if we can't get her connected.
Did you see her message? She said, I'm sorry, I can't hear anything.
Yeah, I see it. Let's just have her join via telephone. I think it'll be easier that way. I'm gonna send her that information.
Okay.
Consent. Looks like she's trying to use a different device. Let's see. Can you hear us now, ma'am?
Yes, I can. I apologize.
Okay, so you're using.
I was on my work.
Okay,
Let me remove this other one here, so we don't get confused. Okay, then we'll swear you in as well. So please raise your right hand, ma'am. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Ms. Petrolio, you can proceed.
Your Honor, it's the case of Denise Rogers versus Kevin Huffman. The docket number is 2012-2113 DM. Mr. Huffman is before the court by way of an adjourned hearing to allow you to hear the matter. And he is responsible to pay $84 a month, current child support. The arrears are to be paid at guideline, which is $42 a month, plus fees for a total of $129.50. The last payment he paid was April 2nd of 2022 in the amount of $23.38. There have been 5 prior show causes, 3 bench warrants, and a contempt finding. The order that was last entered in January that adjourned it to today's hearing was required that he start paying in February. However, there were several adjournments on this case. So if I go back to the last one, not the last one, but the first one in August, it required that he commence payments in September. So actually there would have been 6 months at $129.50 for a total of $777. He's obviously paid nothing since he hasn't paid since April. In fact, in the last 2 years, Mr. Huffman has paid a total of $178, just shy of 2 months of current child support. So a few things I want the court to be aware of is we had to send the orders from the referee hearings require that he provide medical documentation to the court. And we had to send that information out 3 different times. Finally, when we got the first letter that was dated December 21st of 22, there was a box check that says he's, totally and permanently disabled and unable to work. But then in the additional comments, it said that Kevin is unable to work. I feel there is a chance he could be improved with proper treatment. So I called Dr. Holmes and spoke to him on January 12th, and he told me that December was the first time he had been seen in 4 to 5 years. He also indicated that he's not permanently disabled.
I'm going to object, Your Honor. This is all hearsay.
Well, I understand that, but again, she can respond to the medical documentation that's provided. I assume your client's going to render some hearsay as well as to that.
Okay.
Go ahead.
He indicated that he was not permanently disabled, that he accidentally checked the wrong box. It is temporary, and that he suffers from arthritis, but says he's overweight. So with cooperation, he thinks that things that he suffers from could be corrected. If he loses weight, this will help with the arthritis. He does have ADHD, which apparently provides troubles concentrating. He also indicated that the depression is secondary. So he feels if he loses weight and gets back to work, then the depression will subside. I received a doctor's statement this morning that was faxed over from the attorney's office that indicates he is totally and permanently disabled and unable to work. So this totally contradicts what I was told 2 months ago. I'm not sure what would have happened in the last 2 months. But it's a situation where he's got a very small amount of child support each month that he's required to pay and has gone more than 2 years or almost 2 years. Well, 2 years with very little payment. And front of the court believes that the court needs to make a decision on this matter.
Well, was that Dr. Holmes that sent you that today, Ms. Petrulio, or a different doctor?
It was Dr. Holmes.
Well, obviously there's a substantial contradiction there. We need to determine what the scenario is, because it obviously has substantial impact if he's determined to be totally disabled by the doctor.
Yeah, it's the exact same thing that was submitted last time. Except this time he didn't put additional comments, and he spoke to me on the phone about that and believes that, you know, if he lost some weight, everything would fall into
Right.
place.
Well, I understand, but that was in January, and again, we need to have something current or Ms. Petrulio, if we're going to get an update from Dr. Holmes, what time do you think we'll need to get that? I mean, are we gonna need 30 days? There's more time we're gonna need, or what?
I could probably get it within 30 days, I would think.
Okay. Mr. Robinson, do you have any problem with adjourning the matter approximately 30 days to get an update and clarification from Dr. Holmes?
No, Your Honor.
Okay. Why don't we do this? We'll adjourn the matter approximately 30 days, depending upon the next date. It might be a little more than the 30 days, but the court does want to get something from Dr. Holmes that would clarify how he could on January 12th state that he's not disabled and now state that he is disabled. So if you can acquire that, Ms. Petrulio, before that hearing, then we'll be able to proceed.
Okay, sounds good.
Okay, and Ms. Rogers, sorry for the inconvenience of having to be here, but you can understand not getting the information until today. We want to make sure that we have accurate information before we proceed.
Of course, Your Honor, I understand.
Okay, thank you, and the court will end this matter at 11:35 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Okay, I just have some matters for the record.
Okay, go ahead.
Joseph Holland has two cases, and he was ordered to call in for the hearings today. They are dockets 2001-3417 DS and 2013-3451 DS. In both cases, they were adjourned from March 1st to today's date to allow him to be represented by court counsel. However, when he called this morning, it indicates that he started work last night, and I did confirm that. So he hadn't been represented by court counsel, so I don't think that he should be charged for that. And front of the court is just simply asking that both of these matters be adjourned to June 14th, 2022, and that he pay on his own until the income withholding is in place.
Okay. The court would adjourn the matters to June 14, 2023 at 8:00 a.m. to monitor the income withholding.
Thank you. In the matter of Candace Cross versus Antonio Grant, 2008-4175 DP, and Chelsea Stouter versus Antonio Grant, 2019-3093 DP. Front of the court did contact Mr. Grant last week via jail conversation, and he remains in the Calhoun County Jail. It looks like he might only be held on hours right now, though, so it looks like he will be released, but the agreement was that he waived his right to a hearing, that we cancel the bond and allow for his release, and that he is to contact front of the court 14 days upon his release.
Court would cancel the bond previously ordered by against Mr. Grant, allow his release on the front of the court matter, and order that he would contact the front of the court within 14 days of his release from incarceration.
Thank you. And then in the matter of Heather Hampton versus Lorenzo Hampton, docket 2005-4290 DP. Mr. Hampton was also lodged in the Calhoun County Jail. He remains there. Front of the court he waived his right to a hearing and agreed that we would cancel the bond and require that he contact front of the court 14 days upon his release.
Court would cancel the bond previously ordered for Mr. Hampton, allow his release on the front of the court matter, and order that he would contact the front of the court within 14 days of his release from incarceration.
Thank you. And then I had two individuals that were ordered to appear here today for adjourned hearings. Both failed to appear, and failed to comply. They are Brandon Hamilton, 041577 DP, and Drew Holiday, 2021-485 DS. Front of the court's asking that warrants issued pursuant to statute.
Court would grant bench warrants against Mr. Hamilton and Mr. Holliday, as a result of failure to appear before the court today, the court would set their bonds in the amount of 25% of the outstanding arrears or $500, whichever is greater.
Thank you, Your Honor. That's all I have for today.